Morning. Today is Tuesday, December 13th, 2016. It is 10 a.m. It is my pleasure to call to order the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Lisa Mosby, would you please call the roll?
Dennis Bridges.
Here.
Mark Cawthorn.
Here.
Robert Davis.
Here.
Jeff Duffer.
Here.
Robert Helms.
Here.
David Neal.
Here.
Charles Rahm.
Here.
Mr. President, all board members are here and accounted for.
Thank you, Ms. Mosby. Moving on to the agenda.
Motion to approve the agenda as presented.
Second.
Motion, Mr. Rahm, second, Mr. Davis. All in favor say aye.
Aye.
Any opposed? Motion carries. Now to the minutes. Ask for approval of the October 11, 2016 minutes.
Motion to approve.
Second.
Motion, Mr. Helms, second, Mr. Duffer. All in favor say aye.
Aye.
Any opposed? Motion carries for the minutes. Now to the legal report. Today we have a new Assistant General Counsel, Sherelle Hooper, we'd like to recognize today.
Excuse me, I've got to get used to this mic. Thank you all for having me. I'm the new Assistant General Counsel for the board, and we also have Allison Ratton, who the board is already familiar with, and Pamela Spicer. She's the new Assistant General Counsel with our department. So today they will be presenting the legal report, and I will be here to provide other assistance as needed. Thank you.
Thank you.
Good morning. My name is Pam Spicer. As Sherelle indicated, I'm new to the Department of Commerce and Insurance. It's a pleasure to be here today, and I will start with my portion of the legal report. Case number 1 is 2016-05819. It is involving an establishment. This is a consumer complaint received regarding whether a flag was wrongfully withheld from a deceased family due to non-payment of a balance deceased account, who was cremated. The complainant stated that the funeral home refused to provide the deceased family flag that was presented for prior military service because there was a balance due on the account of $185. There were apparently 2 family members involved in this transaction. The funeral home was told by one family member the deceased mother expected to be presented the flag, but there was an email from another family member stating that the funeral home could keep the flag and give it to another military family. In response, the funeral home stated that the balance owed was written off and that the funeral home asked the next of kin if they wanted the flag mailed to them, and the next of kin refused. I did speak directly to the family member who made the complaint. She said that her mother has been made whole by the VA as they sent another flag, but the complainant does not want this to happen to another military family. My recommendation to the board is closure with a letter of warning.
Motion to accept council's recommendation.
Second.
Motion, Mr. Helms, second, Mr. Rahm. All in favor say aye.
Aye.
Any opposed? Motion carries. Next case.
Thank you. Number 2 is complaint number 2016-06681. This is another establishment. This complaint involves a competitor who filed a complaint with regard to the price list used and advertised by the respondent when advertising comparison pricing to consumers. The complainant stated in their complaint that the price list advertised by their products by the respondent was incorrect. The respondent states in response that the respondent relied on the price list received directly from an employee of the complainant when compiling the comparison price advertisements, and no harm occurred. There's no history for this establishment, and I'm recommending closure with a letter of warning.
Motion for recommendation.
Second.
Motion, Mr. Rahm, second, Mr. Helms. All in favor say aye.
Aye.
Any opposed? Motion carries. Next case.
This is number 3, complaint number 2016-066181, 2 and 3, involving an establishment, funeral director, embalmer. This complaint involves forgery of a death certificate. The complainant is the medical examiner who originally signed the death certificate. In response, the funeral home states This issue was resolved in a prior complaint. However, this is a separate death certificate not related to the prior complaint. As you see from their history, they have other closed complaints for forgery of a death certificate. So I am recommending authorized formal hearing, authorized settlement by consent order with civil penalty assessing $1,000 to the funeral home and $1,000 civil penalty to the funeral director / embalmer.
Motion to go with recommendation from council.
Second.
Motion, Mr. Rahm, second, Mr. Duffer. All in favor say aye.
Aye.
Any opposed? Motion carries.
Thank you.
Thank you, Ms. Spicer.
Good morning. Now on to case 4, 201605437 against an establishment. This complaint was filed by a consumer who states the establishment had his mother's body from June 21st through July 2nd, 2016, but did not contact a cemetery or remind the family to contact the cemetery for a burial date and time, but instead, 2 hours before the funeral service on July 2nd, contacted complainant's sister that there is a conflict with the cemetery. This resulted in friends and family having to either miss the burial or take extra time off work. In its response, the establishment states that complainant did not participate in making funeral arrangements for his mother, nor did he enter into a contract for services, but his sisters did. To note that a complaint was not filed by the people who actually made the arrangements with it. It states that one of the sisters told the establishment that her mother had a burial plot and that the sister said she would visit the cemetery to complete the required burial paperwork. But the establishment found out the sister failed to do so when it was contacted by a vault company on the day of the funeral service. The establishment stated as soon as it was made aware of the issue, it contacted the sister, who stated that she had forgotten to contact the cemetery, and unfortunately the cemetery was not able to immediately rectify the situation. Our recommendation is to close this case.
Accept the council's recommendation.
Second.
A motion, Mr. Duffer, a second, Mr. Cochran. All in favor say aye.
Aye.
Any opposed? Motion carries. Next case.
Next case is 2016-055871 against an establishment. The complaint was filed by a funeral director who alleges a casket store, which is not a licensed funeral establishment, and its owner, who is not a licensed funeral director, is offering funeral-related promotions which are misleading to consumers. A consumer brought documents to the funeral director, upon which the funeral director relied to file the complaint. The complainant provided an offer for services from the establishment on a Facebook page that states the establishment will be the one-stop funeral shop you have deserved for many years, quotes the price for a complete casket and vault with vault services in the ground for $11,000, and states $1,100 and states, I'll give you the info on the lowest price funeral home. If you're looking for cremation and paying more than $600, you are paying too much. The complainant also produced what the complainant purports is the copy of a business card from the establishment that was given to a family that is handwritten on it. Cremation and funeral service, $1,000 plus $730 for a casket. On its website, the establishment refers to itself as a casket store and does not claim to be a funeral establishment or have a funeral director on staff. In its response, the establishment says the accusations are false and the establishment has not quoted any package pricing to any family and does not offer the sale of packages in any display price or other media. The establishment agrees that it is not a licensed funeral home and says it does not offer, quote prices, sale, contract, or engage in the marketing of arrangements to provide for funeral services and is not affiliated with any funeral home or holding itself out to be a funeral home. The establishment claims its advertising is not illegal because it does not use verbiage in which the practice of funeral directing can be implied. The establishment states it is a provider of products and merchandise. With its response, it included its certificate of registration for sales and use from the Tennessee Department of Revenue and its minimal activity business tax license. We recommend closing this case with a letter of warning.
Question. The casket store is not under our jurisdiction, is that correct?
That is my understanding.
Letter of warning is nothing.
The letter of warning would not be a disciplinary action. It would advise the establishment owner of that it is illegal to offer funeral directing and merchandise.
Okay. Hypothetically, if they continue to do so, what could this board do? Nothing.
It is unlicensed activity, potentially.
But if they don't have a license that we could take action on. So it's a quandary that we have that they're working outside the realm of our industry.
So besides the letter of warning, there's nothing else we can do.
Not to my knowledge.
Basically, they don't have any jurisdiction. I mean, no one does, other than just a retail establishment, the way I look at it.
And if they continue to, well, I shouldn't use the word continue. If a third-party casket store offers funeral services, then they would come under the jurisdiction of the board through unlicensed activities, you point out, correct?
That's my understanding. The board in the past has taken activity against unlicensed individuals who are purporting to be licensed. In this case, it's inconclusive if unlicensed activity occurred, but should a complaint be received where someone said they went to this store and the person was acting as if he was going to be their funeral director and things went south, then in that case, the board could step in likely.
Make a motion to accept your recommendation.
Motion by Mr. Cochran, second Mr. Bridges. All in favor say aye.
Aye.
Any opposed?
Opposed.
Let the record show that Mr. Davis? Mr. Davis opposed. Motion carries. Next case.
The next case involves 4 respondents. It's number 2016059481234 against an establishment, funeral director, embalmer, and the establishment owner's daughter. The complaint was filed by a former employee who alleges the establishment owner's daughter is writing pre-need insurance policies using the establishment owner's license number and signing his name to the policies, but she does not have an insurance license or a pre-need sales registration. The complaint alleges the establishment owner's daughter also sets appointments for consumers to meet with her and meets with consumers regarding pre-need and at-need funerals despite not having a funeral director license. Upon investigation, the complainant, a licensed funeral director and licensed pre-need sales agent and licensed embalmer who works at the establishment, not an embalmer, stated the establishment owner's daughter wrote 2 pre-need insurance policies and signed the establishment owner's name on the contracts on April 19th, 2016 and April 29th, 2016, though it would have been impossible for the establishment owner to write these policies because he is out of state attending meetings. The complainant provided a copy of the contracts and meeting itinerary and flights that occurred the day the contracts bore the establishment owner's signature. The itinerary shows the establishment owner attended a meeting in Florida from April 17th through 23rd. The flight itinerary shows the establishment owner was on a plane from 11 a.m. until 2:52 p.m. on April 29th. Complainant also states she was terminated from her position with the establishment recently. In her response, the establishment owner's daughter, admitting to assisting customers with pre-need arrangements and filling out the forms, but stated the establishment owner did sign the form on the April 29th instance. On April 19th, she states the complainant set the meeting with the customer but left the office to run errands, and on April 29th, complainant refused to wait on the customer. She apologized for her actions but thought they were excusable in order to treat families with utmost respect. In the establishment owner's response, he admitted his daughter did wrong by signing the contract on April 19th and that he did sign the April 29th contract upon his return to the office. He also stated that because complainant failed to do her job on April 29th, his daughter did help the customer fill out the paperwork. Legal therefore recommends a letter of warning against the establishment owner, and the establishment owner's daughter, noting that discipline in this case should be left to the commissioner's designee in burial services, as this is a pre-need issue, and the commissioner's designee has already authorized a consent order for these respondents.
Motion to approve the recommendation.
Second.
Motion, Mr. Rom, second, Mr. Helms. All in favor say aye.
Aye.
Any opposed? Motion carries. Next case.
The next case is number 2016-058231 against an establishment. The complaint was filed by a consumer who states his father passed away on August 31st and was sent to the establishment to be cremated on September 1st. The establishment called the complainant on September 7th, advising that the body would not be cremated in time for the funeral, so the family had the funeral service without the body. In its response, the establishment stated the county medical examiner requires a death certificate to be completed in order to obtain the cremation permit from the health department. However, the physician who was going to sign the death certificate was out of town and did not have another physician in his office to sign the death certificate until he returned. The establishment did not receive the signed death certificate until September 23rd and performed the cremation on September 26th. The establishment stated it apologized to the family, offered the family an immediate 50% refund, and conducted a meeting with funeral staff to discuss the importance of keeping a family informed. We would recommend to close this case with a letter of warning.
Motion to accept counselor's recommendation.
Second.
Motion, Mr. Duffer, second, Mr. Cochran. All in favor say aye.
Aye.
Any opposed? Motion carries. Next case.
The next case is against an establishment and the establishment's employee. It's number 2016-066161 and 2. A complaint was filed anonymously by a consumer alleging that the establishment employee solicits the bodies of deceased loved ones from families. The complainant states he is persistent in calling and going to people's houses and has gone to hospitals looking for bodies and asking for leads. The complainant admitted to not knowing how he gets the addresses or phone numbers and has threatened to call police on him, but he gets someone else to call. The complainant did not provide a way to follow up with him or her and did not provide the contact information of anyone that might have additional knowledge of the alleged acts. In its response, the manager of the establishment denies the allegations, stating the establishment does not conduct itself in the manner alleged in the complaint and she has no knowledge of the misconduct alleged. She states the establishment does not promote or encourage interfering with families or soliciting remains at any time. According to the manager, once a family is contacted or been referred to the establishment, does the establishment proceed to serve the families? In his response, the establishment employee stated that he has been employed by the establishment for over 45 years of its 80-plus years of service to the community and stated it is not and never has been part of the establishment or his personal practice to solicit business from the families in their time of need. He stated the establishment has established relationships with churches, hospitals, and other funeral homes that refer the services of the establishment to families in their time of need. Legal would recommend closing this case with a letter of warning.
Motion to accept.
Motion, Mr. Helms, second, Mr. Rom. All in favor say aye.
Aye.
Any opposed? Motion carries. Next case.
Next case is against an establishment and a funeral director. It's number 2016-067131 and 2. The complaint was filed by a competitor who states a source told him about alleged fraud that occurred at the establishment by the establishment employee. According to complainant's source, 2 sisters passed away, one in 2015, who I'll refer to as decedent 1, and one in 2016, who I'll refer to as decedent 2. According to the source, they purchased 32-ounce copper caskets that range from $9,000 to $11,000 in price, but were buried in 18-gauge non-sealer copper-colored steel caskets, which range from $4,400 to $4,600 in price. According to the source, an additional decedent paid for an 18-gauge sealer and was buried in a 20-gauge non-sealer decedent 3. And allegedly, the The funeral director pocketed the difference. But in his response, the funeral director states the allegations have no merit. He denies the claims that any funds were pocketed and describes the checks and balances in place to record payments received, and if there is an issue, the logbook, ledger, check copies, contracts, bank entries, and deposits are reviewed. He states all options and differences were explained to the family members, and deviating from the pre-need selection was the family members' choices. He states decedent 1 and decedent 2 selected a Neapolitan blue copper Batesville casket pre-need. He states decedent 1 was buried in the casket that was selected on the pre-need basis. He states a relative met with him to arrange the services for decedent 2. The relative allegedly chose a Neapolitan 18-gauge Batesville gasketed casket over the copper casket. Decedent 3 selected an 18-gauge purity gauge casket that has been discontinued. He states decedent 3 relative liked the 20-gauge white Gemini non-gasketed casket, and he explained to her that it was different from the casket selected by the decedent. In his response, the funeral director provided decedent 1's statement of funeral goods and services selected, which indicates $5,995 was paid for a Neapolitan blue copper casket. In his response, funeral directed decedent 2's statement of funeral goods and services selected, which includes $3,695 was paid for an 18-gauge Neapolitan casket. In his response, the funeral director provided decedent 3's statement of funeral goods and services selected, which indicates $2,595 was paid for a Gemini white casket. The source responded to the complaint stating he had no recollection of what sort of casket decedent 1 was buried in. He states decedent 2 arranged pre-need for a copper casket but was buried in an 18-gauge casket because her relative, her sister, and her next of kin chose the 18-gauge after she was given the choice of 2 because she liked it better. He states decedent 3's family was told the casket selected pre-need was discontinued and thus chose the casket that they liked. The source stated he has never witnessed fraudulent activities in his 10 years employment in the funeral industry. Legal recommends closing this case.
Motion to accept.
Question? Of course, this gets back to pre-need issues, and cases like this won't get discovered through the audit until the year after. I mean, how do we know how these were handled?
This case,
Did the family receive a refund on unused monies? If they did, in purchase the more expensive caskets on the pre-need side?
I don't know the answer to that. I just know that the statement of funeral goods selected showed the prices that were put for the caskets, and they were far less than what the source allegedly told the competitor was paid. And the source himself says that he...
The question is basically, is there a refund? Was there a refund? Did the family receive the excess monies?
We didn't note if a refund was provided in our findings, but can certainly look into sending a letter trying to provide evidence that one was provided from the establishment.
Did we, sorry. Did we see evidence that price, so we know the complainant said that this price was paid to the competitor. What, did you find evidence that it was actually paid? I guess my question is, did you find evidence that a refund was actually warranted? Does that make sense?
No.
Or was that just an allegation that hey, these people paid $9,000, they only got a $5,000 casket, they deserve a refund? That was the allegation, but did we prove that actually happened?
That was the allegation, but we did not prove that.
Okay.
The statement of funeral goods and services that were submitted, were they signed by both the family and the funeral director?
I believe so. I don't recall off the top of my head. But
That would indicate they understood what they were paying for.
My question goes back to the pre-need side of it. If they have, say, $11,000 worth of pre-arranged funds and they use $8,000, I want to see whether.
And that's a great point. This case is open on the pre-need side and is to be presented to the commissioner's designee maybe on the December 20th meeting, but that's certainly a fact that we need to tighten up.
I recommend we turn it over to the pre-need designee and to audit these cases, because it looks like there's a trend. We know of 3. I'll put that in a motion.
Second.
Motion, Mr. Helms, and second, Mr. Rahm. All in favor say aye.
Aye.
Any opposed? Motion carries. Next case.
That concludes the new cases. We do have a pretty lengthy set of cases to represent to the board that were previously presented to the board at the October meeting. These are cases 2016-022541 and 2 against an establishment and a funeral director, and cases 2016-0376-1 and 2 against a funeral director and an establishment. In these cases, the complaint was filed by decedent's son, who states he received a phone call from the funeral director that his father was put in the wrong clothes, wrong caskets, and buried in someone else's grave in the wrong cemetery prior to decedent's scheduled funeral service. Complainant stated and later confirmed via sworn affidavit pursuant to the investigation requested by legal that the establishment offered to provide a closed casket funeral the day after the service was originally scheduled, but instead complainant's children went to the establishment and verified the body intended to be presented for decedent's funeral was not their grandfather. Complainant's son signed an affidavit of disinterment so decedent could be retrieved in time for a scheduled funeral, yet funeral director refused to provide verification of the exhumation. However, a photo of same was obtained on a phone camera and submitted with the complaint. The exhumation was scheduled for 7:30 on the morning of decedent's scheduled funeral service. Complainant alleges the body was brought to the funeral approximately 15 minutes before the funeral service started and approximately 2 hours after the scheduled visitation. In a sworn affidavit pursuant to the investigation, the cemetery sexton where decedent was buried stated that he was present for a decedent's graveside service. The casket was placed into a vault, lowered into the grave. The grave digger filled the grave. The cemetery sexton advised later that evening he was called by funeral director and told the decedent was in the wrong casket, so he met funeral director and a representative of the vault company the next morning. The cemetery sexton stated that the vault was brought up, top removed, and casket placed in the establishment's van. The funeral director verbally told the investigator that the vault was cracked, and he decided to come back the next morning to replace the vault. The investigator asked if the funeral director left the cemetery with the body, which he replied no. There would have been a reason to leave. No, there would not have been a reason to leave, the funeral director stated. The new vault was placed in the ground, the casket was placed inside, and it was covered. The investigator called the vault company, and the manager's statement via sworn affidavit conveyed the vault provided was undamaged, not cracked, and had known defects, and it was brought up from the ground. It was undamaged. He also stated that the establishment put the casket in the establishment van and left the property. The manager further stated if the product had been cracked, he would have done a warranty exchange and would have charged the funeral director, but the vault provided was not cracked. In his response, the funeral director alleges he misplaced decedent's clothes, but he provided a complainant a full refund and stated the decedent was properly dressed in time for the funeral. The complainant's attorney confirmed a full refund had been given. Also previously presented at the October 11th, 2016 meeting are these set of facts. Based on the affidavit for disinterment submitted by the complainant for the case I just described, the establishment buried complainant's father in this complainant's husband's grave, then exhumed him, presented him for his correct funeral service, and then buried him in a correct grave in a different cemetery in another city. In this case, the establishment did not contact the complainant at any time to let her know of the error. Upon exhuming the decedent from the prior complaint, the funeral director took the casketed body back to the establishment for what the cemetery sexton believed was to switch caskets. In trying to determine the facts of the prior complaint, legal contacted the complainant to determine what she knew. At the time of the phone call, she was completely unaware of the switch. The complainant was clearly distraught and wept while legal spoke with her on the phone. She acknowledged that the decedent had on the proper clothes and was in the proper casket. The complainant sent the establishment a demand letter for full reimbursement for the funeral costs on June 16, 2016. According to her sworn affidavit pursuant to the investigation, complainant stated that in viewing her husband at the visitation, which was open casket, she thought the man in the casket was her husband, but it did not look like him, which she thought was due to the makeup, the embalming process, and the injuries he obtained prior to death, where he fell and bruised his face and teeth. Complainant's daughter told her that she did not think the man in the open casket was complainant's husband, and even asked the funeral director about it, who told her the makeup and the length of time accounted for the difference. The funeral director assured the daughter the person in the casket was complainant's husband. Complainant's sister-in-law also commented to her that the body in the casket did not look like the decedent. Legal called complainant on August 2nd to follow up on the reimbursement letter, and complainant stated that she had not heard anything from the funeral director or establishment. Complainant again told legal of the heartaches of still not knowing whether her husband was buried in his proper casket or clothes, because she was never informed of anything and never received a funeral service for her husband, as the wrong person was presented by the establishment in her husband's place at her husband's funeral. A response was not submitted for this complaint. The updated information for these cases are as follows. On October 10th, 2016, from 4:24 p.m. to 6:20 p.m., the day before the October Tennessee Board of Funeral Directors and Embalmers meeting, the funeral director's assistant sent legal 5 emails admitting the submission was last minute, but hoping legal could glance it over before the board meeting. The emails contained 81 pages and consisted of 6 affidavits and 2 decedents' funeral files. It is legal's position that funeral director did not timely provide a response and information to the board. However, legal has since reviewed his information and is representing this case based on that additional information for the board's consideration. The dates of the funeral services for the 2 decedents and that a disinterment occurred on December 30th at funeral director's request is not disputed. On December 29th, a funeral service was held for decedent 1 at the funeral establishment, then a burial occurred in Cemetery 1. On December 30th, decedent 2's funeral service and burial was scheduled to be conducted by the funeral establishment. On December 29th, decedent 2's son stated via sworn affidavit he received a phone call from the funeral director, who told him decedent 2 had been put in the wrong clothes, wrong casket, and taken to the wrong funeral and buried in the wrong cemetery in someone else's grave on December 29th. On December 29th, decedent 2's son sent his children to the funeral establishment, who then verified the body purported to be decedent 2 did not look like him. The funeral director told them they had to sign an affidavit of disinterment. The affidavit, dated December 29th, reads as follows. This affidavit is in keeping with Tennessee law regarding the disinterment of my relative, decedent 2, who is presently interred in Cemetery 1. The reason for disinterment is to relocate the decedent. He will be reinterred with the family interred in Cemetery 2. Funeral director's information submitted October 10th states as follows. Via his sworn affidavit, funeral director's assistant remembers the funeral director calling decedent 2's family and decedent 2's family members coming to the funeral home on December 29th. She also states the funeral director requested she provide a template form for a disinterment and notarize the signature of decedent 2's family member. Funeral director's assistant provided a copy of this affidavit in her October 10 emails. On December 30th, a disinterment occurred at Cemetery 1. Funeral director's sworn affidavit says he noticed decedent 1's grave liner was damaged, so he contacted the vault company and had it replaced on the morning of December 30th in Cemetery 1. Funeral director's affidavit denies decedent 2's claim that decedent 2's body was late to the visitation, but admits he upsets decedent 2's son and gave him a full refund. The affidavit makes no mention of his phone call to decedent 2's family on December 29th or why an affidavit of disinterment was procured from decedent 2's family on December 29th when decedent 2's burial wasn't until December 30th. In legal's opinion, what funeral director information fails to explain is why an affidavit of disinterment was procured from a family the night before their loved one was to be buried. Legal finds decedent 2's family's version of the events credible, especially given the affidavit of disinterment, which states decedent 2 was buried in decedent 1's grave and authorizes the disinterment of decedent 2. Legal is unpersuaded by the additional information provided by funeral director and recommends no change to the board's previous authorization. Therefore, legal recommends for all 4 cases keeping the previous recommendation.
It was certainly a miss. That's what it was.
Agreed.
Motion to accept recommendation.
Second that.
Motion, Mr. Rom, second, Mr. Helms. All in favor say aye.
Aye.
Any opposed? Motion carries. Thank you, Ms. Ratton.
Thank you.
Now to the director's report, Mr. Robert Gribble.
Thank you, Mr. President. First thing I'd like for us to talk about is the financial data for the fiscal year 15-16. This runs from July 1, 2015 through June 30, 2016. First document we'll look at is what we term a financial recap. Financial data was provided to the board's executive director by the Assistant Commissioner's Office for Regulatory Boards of Tennessee Department of Commerce and Insurance on November 4, 2016 for use in compilation of this report. The beginning balance, July 1, 2015, was $983,166. Net revenue, or earnings, for July 1, 2015 through June 30, 2016, was $772,915, making total funds available $1,756,081. Expenditures, July 1, 2015 through June 30th, 2016, $370,473. Cost backs, these are cost allocations charged back to the board from administration, investigation, legal, and the customer service center. $144,355, making the total expenditures including cost backs $514,828, leaving a reserve balance on July 1 of 2016 of $1,241,253. And then if you look to the next page, and I'll be glad to answer any questions that you have or expound upon any part of it. But the next page gives you a comparison of 4 years, going back to FY 12-13, and then for 13 and 14, 14 and 15. I think you'll see that the expenditures are what I would term fairly consistent. Cost backs are fairly consistent except for FY 14 and 15, and if you'll notice there, legal and administration was together. Legal was not separated, and you can see that legal runs about approximately $60,000 each year, and if you were to separate that from that year, then it would be pretty consistent with everything else. The reason we do not have any field enforcement is we have our own, the board has our own field representatives. So field enforcement's a separate division or a separate section of the department that, like motor vehicle, uses cosmetology and barber and nose boards like that. So that's the reason there's no charge there for that part. Investigation, one of our people is an investigator, and the field representatives can do limited amounts of inquiries and things of that nature, but occasionally we do need to, for expediency or other reasons that legal may determine, we do need to use the investigation section of the department. So that's why you see small amounts of expenses there, but not any significant amounts on that part. As you're aware, the revenue, we're up and down every other year because we still have most establishment license and most funeral director and embalmer license renew on the June the 30th of even numbered years. So that makes that flow up and down. The one year we had the core expense. Core is the new licensing system. That was when we need to set money aside from each board to purchase the new licensing system. And that was back a couple of years ago, but no money expense for that. Talk about this later, but we've kind of talked a little bit about, I think when the new board member taken, you may want to consider reducing obviously this $1.2 million is money that licensees have paid, that applicants have paid. It's, and can be taken and used in the general fund. That's not completely unheard of, so I guess I'm saying that to say it does no good to accumulate a huge balance. We've always thought that the balance need to be sufficient for, well, we first thought for 1 year, and then we were told maybe for 2 years, but you can see based upon the expenses that we've accumulated now a 2-year reserve that so that we can have ups and downs in the economy, and certainly that can affect all businesses, but our number of licensees stays pretty consistent. For the past 10 to 12 years, we've had about 3,000 funeral directors and embalmers and about 550 or 60 establishments. And even in, no matter what the economy does, that has stayed fairly consistent. I'll be glad to answer any questions that you have, and also will mention to you that the Assistant Commissioner for Regulatory Boards and the accounting manager that works in his office, they will probably come to the board and talk to you February, March, or something like that. But this information we've gotten since the last board meeting, and we wanted to pass it along to you while it was still recent. And does anyone have any questions? Next item is the performance and compliance audit. As we mentioned in previous board meetings, the Tennessee Comptroller of the Treasury Division of State Audit continues in the process of conducting a performance and compliance audit for the Board of Funeral Directors and Embalmers and other regulatory boards within the Department of Commerce and Insurance. Since the last board meeting on October 11, 2016, Ms. Lisa Mosby, who is our board's administrative manager, and I have responded to the auditor's questions that were sent via emails, and also we have had a face-to-face meeting with the auditors. The performance and compliance section of the Comptroller's Office conducts performance audits based on identification of risk and statewide processes and programs for agency-specific operations and activities. This section also conducts performance audits to evaluate the efficiency and effectiveness of government programs in accordance with the Government Entity Review Law. In coordination with the Financial and Compliance Audit section, this section is responsible for auditing functional areas of departments, agencies, and institutions of state government, as well as federally sponsored programs in accordance with the Single Audit Act. And we'll continue to update you as this audit processes. As we mentioned earlier, this is typical when we're coming up for sunset review. It's typical to have an audit of this nature, and as to how long it will last, we don't know. Probably my speculation is another 2 or 3 months anyway, but I don't know that. That's just pure speculation. But we do try to provide information they request in a timely manner and get whatever documentation that they request. Legislative update for today's board meeting. As reported at the October 11, 2016 board meeting, the board office has been informed of at least one potential bill that may be introduced during the next legislative session that addresses circumstances where a funeral establishment is initially selected, but the authorizing agent later decides to move the decedent to a subsequent funeral establishment. And reportedly, the bill will require the initial funeral establishment to release the remains to the funeral home selected by the authorizing agent, but either the subsequent funeral establishment or the authorizing agent shall be responsible for the charges provided by the initial funeral firm, and the amount shall be payable to the initial firm at the time of release of the decedent to the subsequent funeral establishment. Additionally, it is anticipated that the Tennessee Funeral Directors Association will have potential bills in the upcoming legislative session, but as of this time, there's been no official communication to the board office regarding that. Now, there has been regarding the previously mentioned bill that we mentioned last month. The licensee report. It's a report of licenses administratively approved by the Executive Director pursuant to the Board authority for the period of October 11, 2016 through December 12, 2016. Proposed establishments. There are 2 establishments that reported closing since the last board meeting. West Murley Funeral Home, Huntsville Chapel, which was located at 3096 Baker Highway in Huntsville, Tennessee, and Shackelford Funeral Directors, which was located at 9642 Highway 22 South in Mickey, Tennessee. So those 2 have closed. Disciplinary action report. This is a report of consent orders administratively accepted or approved by the Executive Director pursuant to the Board authority for the period of October 1, 2016 through November 30, 2016. Lastly, the complaint report. Ms. Mosby says that there are 23 total complaints pending before the Board of Funeral Directors. 6 of those are against Funeral Director and/or embalmers, and 17 against establishments as of yesterday. President, that concludes my report.
Thank you, Mr. Gribble. Ask for approval for the director's report.
Motion to approve.
Second.
Motion, Mr. Helms, second, Mr. Duffer. All in favor say aye.
Aye.
Any opposed? Motion carries. Now to approval of license applications.
Mr. President, you have 2 individuals coming before you today. The first one is Mr. C.J. Williams. Mr. Williams, if you would, please come up and have a seat to your left there, and into the microphone there, whichever you can adjust the mic to you there. It's just, if you don't care, make sure that the red light is on when you're speaking. And let me just one. Mr. President, Mr. Williams is from Brinkley, Arkansas. He's applying to the Board for Funeral Director and Embalmer license for reciprocity from the state of Arkansas. And the Board, among other pertinent statutes and rules, specifically may want to examine the Tennessee Code Annotated 62-5-317, making determinations whether the applicant meets the requirements for licensure. Mr. Williams, if you would, briefly identify yourself and tell the Board your purpose for being here today.
My name is C.J. Williams. I am applying for I currently manage a funeral home, which I have been I do a lot of trade embalming. We kind of have a shortage of embalmers in Can you hear me now? I'm sorry.
You can pull it closer to you. I
Okay.
think. Yeah,
I'm sorry.
There you go.
I'm sorry. But who recently opened a funeral home in Memphis, and he needed so far doing pretty good over there. So, and I told him I wouldn't mind helping him if I could help in any way, because like I said, I do a lot of trade embalming for. I do all my embalming at the funeral home I manage. So, out anywhere, I don't mind doing it. So.
Williams, on your application, it was indicated that you had never been disciplined by the state that you were licensed in. Is that correct?
I went to the board once for a complaint, but I can't remember.
I can tell you, you marked no, that you had never been disciplined. What took place in the time that you were before the Arkansas Board of Embalmers and Funeral Directors?
We had a situation with a family we took care of the young lady. She was an autopsy case, and I did the embalming. We went through the funeral process and everything. Well, the viscera was left out of the remains. They were treated and everything, but they weren't put back into the body because she was she was a kind of a bad situation. And I couldn't put that back in her, but we were going to put it inside the casket with her. But it some kind of way got left out. But we went back to put the viscera back into the grave with the young lady. Well, the family took it upon themselves to go out to the grave site and dig it up. And then they filed a complaint.
Family didn't know that you went back out there, did they? Or did they?
They didn't. After I had informed them that it had been left out, but that we had taken care of it, that's when they went out to dig.
You spoke to the family and told them it was taken care of. What did you say?
Well, I told the mother that there was a mistake made in returning all of her daughter's remains to her. I informed my employer that this had been done. I informed the family. And she asked how I took care of it. And I told her what I had done. Well, I guess maybe a couple of weeks later, she decided to go out and dig. And she did.
Was this your decision?
It was my decision. It was.
I think the Arkansas board suspended your license for 1 year. Is that right?
Probation for 6 months.
Probation, okay. Excuse me.
My individual license was on probation for 6 months, as well as the funeral home license.
And sorry for the one person who's outside the industry. What was left out of the?
Viscera.
Yeah. Okay, thank you.
Oh, I'm sorry.
Sorry, I'm the consumer representative.
Right, okay. Yes, I understand.
Just to clarify, you said that your license and the establishment license was on probation for 6 months?
I think that's what it was.
But the order that we have copies of says 1 year.
I can remember I had a letter and everything like that said 6 months. Have any other disciplinary actions or anything, any other complaints after 6 months, we were okay.
We're just going on the record that we have here.
I mean, I understand, yeah.
What was the final outcome of the situation, the viscera?
Well, she did sue us civilly, and we prevailed. The court said well, and it was a jury trial. The court said that we didn't fully carry out our mission to take care of it, but she didn't win anything. So, as a matter of fact, I think the court dismissed it because she was asking for an egregious amount of money, and the jury said no, we're not going to do that. But
I think our issue today is your application and how looks like you're trying to mislead the board and not fully disclose what's going on in your past, because both of your applications said that there's been no disciplinary actions. I think that's our concern.
I guess at that time I wasn't thinking about that because it's been
8 years. Yeah. Oh, wait.
I have a question. Was it presented with the application, or was it obtained by the board office?
Whenever the certification for licensure came from the Arkansas Board, it was sent along with that, which is customary. Like if we do certification to another board, then we disclose any disciplinary action. And I had a phone conversation yesterday with my counterpart there in Arkansas, who's the executive director, and to see if, I did not personally know if 1 year probation was considered disciplinary action, and she said it is, that is disciplinary action. Different director that was employed by the board in 2008 when this occurred than the one that I spoke with yesterday. But when they did the certification of licensure, if you go back one page before the order, when it asks, has the license ever been disciplined by your state board, revocation, suspension, probation, etc., the board put yes, and then said, see attached copy of order. So there were no formal charges pending at this time against the licensee.
The position that you hope to receive at the funeral home in Memphis, is it managed just as a funeral director embalmer? What would the
Just
position?
as a funeral director embalmer, just basically a backup embalmer.
So you would not be in management, not be making decisions as far as?
No, sir, I wouldn't. I have enough going on over at the funeral home I'm currently.
So this would be in addition to, you would just be embalming for this facility?
I didn't have anything going on as far as in the line of a service. Overwhelmed, and they needed a funeral director. I could help there as well, but I wouldn't be making any decision as far as the business is concerned, no.
Are you still in management in your facility? Okay.
What is the distance from Brinkley to Memphis?
About 60 miles, I guess, yeah.
If presented with the same scenario with this young lady's family, would you make the same decision again?
No, I would probably go about it a different way. You learn. You live and you learn.
You indicated the firm in Memphis is a fairly new firm?
Yes.
All right. How new?
I don't know, maybe they're by Premier.
Are they aware of the previous disciplinary action taken by the Arkansas board? Okay.
So this actually started in 2006. This actually started in 2006, is that correct? And then it went in through the board, issued the order in 2008.
Right.
Executive Director told me yesterday that there was a formal hearing conducted similar to the same fashion as this board. Another question I had to her, was this a consent order? It was an offer to settle, and she said that the order indicates that it was a hearing that was held. And of course, in paragraph it says that the hearing, but I didn't know if that was a formal hearing or not. I didn't know, how their procedure. Because I had questions also about C3 and C4, because I didn't really know what that meant, and she just said that those particular charges that the board determined were not proven. So obviously she said she could furnish what those were, and I said no, if it wasn't proven, it's irrelevant to what they were. So I told her we didn't need any additional information other than the order.
So the viscera was cremated as well? Is that correct? I mean, is that taken through the cremation process?
No, she wasn't cremated. She was buried.
She was buried.
Yeah,
Okay.
she was buried, and she was buried in a 20-gauge steel sealer casket in a concrete.
There was no
vault.
cremation that took place in this
No.
previous.
No, it was not.
So, Mr. Williams, then the viscera was in place inside the casket when the family exhumed the body, correct?
It was not. It was buried with, in the grave in a container with the vaulted remains. I had offered to the family, as a matter of fact, to do a disinterment, replace the vault, and put the viscera inside. And they said no. I offered that before we went through all of this.
I don't follow that line of reasoning. When did you offer that to the family?
I offered that when I discovered what had happened.
What did the family tell you to do with the viscera?
They told me that the mother said she didn't want to talk about it, and I asked her if I could get her permission to do that. She said, no, I don't want my baby dug up again. And I said, well, I have a way I can handle it. I could put it in a casket, a baby casket, bury it with the vault on top. And she said, I don't care. Whatever you do is fine. Back, like I said, maybe a year and a half, two later, they go out, dig it up, and call the newspapers.
But what I'm reading here in F6, it states that there was a suspicious-looking plastic bag, so you did not use the infant casket?
I didn't use the infant casket. It was well-wrapped and put in because the infant casket, the graves over there are not, in that particular cemetery, are not very deep, and it's sandy ground. The baby casket would not have gone in, it would have left, part of it would have been left out. The top of it would have been left out. And I couldn't go over into someone else's grave.
You chose to go to the foot of the grave.
Go to the foot of the grave to put the remains there.
Approximately 6 inches in depth, is that correct?
They claim it was 6 inches, but it was actually deeper than that when my employees and I went out to do that. But like I said, it's a sandy cemetery, it's a sandy ground cemetery, and it's on a hill. So I recently, if this will here kind of give you an idea, was called out to the cemetery, that very cemetery, because some human remains had washed up from I guess maybe an old grave or something. and it wasn't anybody that I had buried, because I could tell they were pretty old. But the lady said she was out around her mother's grave, which I don't even bury in their family, and she saw, and I went out there, but I took the cemetery sexton out with me, and sure enough, there was part of a skull, there were some ribs, there were other bones there. So, but I took the cemetery sexton, I contacted the police and told them what, we need to get this done. But the cemetery sexton and we gathered everything, and he asked what I wanted him to do. I said, I don't know. I said, I've had enough trouble in this cemetery, so I don't know. That's whatever y'all decide to do. Because, of course, they were unidentified. I'm sure they were probably from an old grave that had been there for some time. And who, when around that grave or whatever, or he thought he was digging it, he probably ran into it and didn't even know it was there. But
Mr. Williams, you realize that situation is very serious, right?
Right.
For those 2 years, that affected what you were doing
yes.
in the business, right? And moving forward, you said that this gentleman that you would like to embalm for in Memphis, he was aware of this? You told him?
He was around because he's someone I consulted when I was going through all of this.
And then going back to question number 5 on your license application for funeral director and embalmer, isn't that question clear?
What was the question?
The question number 5 on your application that you answered no to, wasn't that clear to you?
What was the question?
Has license to practice as funeral director or embalmer in this or any other state ever been disciplined? If yes, please explain. Both of these applications you marked no.
Like I said, I wasn't thinking at that time about that, because it's been 8 years. Like you said, it's 8 years, but it's been 8 years.
But something as important as this, I would think that would be something you could never forget.
Something you don't ever forget, but it's something you try to forget as far as the things that I went through. Yes. No, I'm not trying to purposely mislead you. I am not. I am not trying to purposely mislead you, but that was a rough time.
Mr. Williams, it's my opinion that it's the responsibility of this board to issue licensees licenses that uphold the highest of ethical standards in their practice and how they treat their community. And as a personal opinion, I cannot personally support your application because of what has taken place. I think you acted very unprofessional and very irrational in your decision.
I think if you had been forthcoming on your application, and you would have checked yes, and you would have given us an explanation, and we would have given you an opportunity to tell your side of the story, that would have gone a long way. Very simple question on each application, and you have to take your professional responsibility very serious on when you do have actions that come before you. I'm struggling with the application request.
I'll just go one step further. I'll make a recommendation that the application be denied.
A second.
Motion by Mr. Rom, a second by Mr. Helms to deny the application. All in favor say aye.
Aye.
Any opposed? Motion carries. Is there a time you can come back to reapply for this, Mr. Gribble?
Technically, he can reapply today or tomorrow, but,
No
I mean,
time limit.
it's in the board's discretion
Again.
that's setting at that time to make a decision whether to approve or deny it. To,
Had a problem
you know,
next time and you come through
that,
before coming then.
But technically, I mean, I don't know if the board has the authority to set a time before they reapply or not, but I mean, technically, if a license is or if a license is denied, if an application is denied or a license is revoked, technically, the person could reapply immediately thereafter. And whether or not it be approved would be up to the board members setting at the time that the application is presented to them. Next person on the agenda is Cynthia Page Stanford. She is from South Haven, Mississippi. She's applying as a funeral director and embalmer through reciprocity from the state of Mississippi. The board may wish to look at Tennessee Code annotated 62-5-317 and making a determination as to whether the applicant meets the requirements for licensure. Additionally, if the board should decide that the applicant does meet the requirements for licensure, I would recommend that the approval be conditional on the following factors. Number one, the applicant must successfully pass the Tennessee laws, rules, and regulations examination prior to licensure, that her facts do not change prior to the issuance of the license, and it would be her responsibility to report to the office any change in the facts in the application, and that all requirements for licensure be met prior to the expiration date of the applications, which is 90 days from the time that we received the applications. Mr. Stanford, if you would identify yourself and briefly tell the board your purpose for being here today.
My name is Cynthia Page Stanford. Licensed as a funeral director and embalmer in Mississippi, and I'm just hoping to take that into Tennessee. I've been offered a position at Munford Funeral Home, Millington, director and embalmer, depending on whether I get my license or not, of course.
Board members, the reason she's before you today without having passed the law test, as you may notice, she has made one attempt at that and came very, very close, came within 1 point actually of passing it. But since it's customary that the board probably will not meet in January, her employer had asked if she could come today and the board either approve or disapprove the application based upon those conditional facts that we talked about earlier, so that they would have a decision prior to that time. So we have an application. She met all the requirements with the exception of passing that test. And she has to wait 30 days from the time she initially took it, which is probably about 3 more.
Yes, I can schedule it again December 30th is when I'm available.
So the only thing to her detriment is her employer? We won't hold that against you. And a licensed funeral director and embalmer for approximately 6 years, is that correct?
No, sir. I've just recently been licensed this past year in Mississippi.
I was just going by your national board test date.
Oh, no, sir. I passed that when I finished mortuary school.
I would make a motion that the application be approved contingent upon her passing the law exam.
Second.
Second.
Motion by Mr. Rom, second by Mr. Cochran and Duffer. Favor say aye.
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 Any opposed? Motion carries. Congratulations.
Thank you so much.
Moving on to new business. Election of board officers for 2017. Upcoming year is the president.
I'd like to make a motion to recommend Robert Helms to the position of president.
Second.
Motion, Mr. Rom, second, Mr. Cochran. All in favor say aye.
Aye.
Any opposed? Motion carries. Mr. Helms be the president.
Appreciate that. Thank you.
Congratulations.
Thank you.
Now to the vice president.
I'll make a motion to present Charles Rom as vice president for the upcoming year.
Second.
Motion, Mr. Helms, second, Mr. Bridges. Mr. Rom be the vice president. All in favor say aye.
Aye.
Any opposed? Motion carries. Mr. Charles Rom be the vice president.
Congratulations.
Thank you very much. Appreciate your support.
Now to the continuing education liaison for 2017.
I'd like to recommend Mr. Jeff Duffer as the continuing education liaison.
Second.
Motion, Mr. Rom, second by Mr. Helms. Mr. Duffer will be the continuing education liaison for 2017. All in favor say aye.
Aye.
Any opposed? Motion carries.
Mr. Duffer, I didn't speak with you beforehand. I hope you're okay with it.
Thank you, gentlemen. Appreciate that.
Any new business to come for the board?
Normally, the outgoing president makes about a 30-minute speech.
Pretty best speech.
And buys lunch.
What? I don't know about the speech.
I second that, Charles.
Actually, you may want to say some words before you adjourn.
As for the adjournment.
So moved.
Second.
You got off pretty high.
Very good.
I still haven't received a letter, so I could be back there. I'm good, Harry.